My Lords, may I start where I finished, which is at 10 over, which is in tab 12, no, tab 13, page 453, simply to remind the Court of the key propositions that are set out in the Advocate General's opinion, and to make the submission that the reasoning behind them applies equally well to legislation cases as it does to Barber-type cases. So one begins at the bottom of the page against letter H.
So which page?
Page 453, my Lord, letter H. In considering the issues arising in the present cases, it's crucial to understand how occupational schemes, contracted out and supplementary, are built up and run. Most of these pension schemes are characterised by their accruing nature. In practice, an employee accrues pension entitlements on the basis of his periods of service with the employer concerned. That, of course, is a consideration that applies equally to legislation limitations as it does to judge-made limitations. It then makes reference to the fact that contributions are periodically paid, but as we'll see in a moment, the Court recognises that not all schemes are contributory and doesn't suggest that that matters. Then on the next page, page 454, between D and E, the Advocate General, I should say, says that from the legal point of view, this accruing nature of occupational pension schemes leads to a distinction between the coming into being of pension rights, namely as a result of the accrual of the pension on the basis of competing records of service, and those rights becoming exercisable, namely when the pension falls to be paid for the first time. And in financial and economic terms, the balance of such occupational pension schemes is also based on a number of premises, including data concerning lifetimes, survival probabilities, etc. So, my lords, my lady, my lords, my submission, this is not just a pragmatic conclusion that this is the right way to deal with pension cases. It was also regarded as being appropriate from the legal point of view because of the way in which pensions are deferred pay that accrue at one stage and are paid much later on. But again, those considerations apply equally to legislation cases like this one as they do to judge-made cases, as in Barber and Tenova.
What does he mean by the balance of such occupational pension scheme?
I think it means the financial balance, in the sense that there are assumptions made about how expensive ultimately pensions will be on the basis of an actuarial...
But that's relevant to contributory schemes, or not?
Not just to contributory schemes, also to where the employer pays for the scheme in one way or another.
Yes, I see.
Because the employer will still need to know ultimately how much money it will have to...
Well, trustees of pension funds are having that problem all over the country now, aren't they?
Indeed so.
It's principally a valuation of assets problem more than a prediction of behaviour, but they're being asked all the time to decide whether there's enough in the pot.
Indeed so. And as I understand it, there's a perfect storm at the moment because, on the one hand, people are living longer than was anticipated. Yeah. On the other hand, investment returns haven't been as generous as people had hoped that they would be.
Yeah. But are publicly funded pensions of the kind we're dealing with in Europe, in these appeals, in the same category, or are they paid out of current revenue?
They are paid out of current revenue, as I understand it, my lord. As I understand it, this was dealt with on the previous O'Brien Supreme Court case in the evidence, as I see my lady recalls. And I hope I'm right in, we did check the judgment to see if anything was set out there, but there wasn't anything. As we recollect the position, it is that effectively the Ministry of Justice and its predecessors would remit a portion of the funds that it was given by the Treasury back to the Treasury as a contribution to what would ultimately be the pension payments. There was no ring-fenced pot for judicial pensions. They are paid out of the consolidated fund or funds voted by Parliament. In answer to the implicit question behind my Lord's question, my submission, that doesn't make a difference in the present case, and I'll show you in a moment in one of the authorities that the scheme is statutory rather than a traditional private sector trust scheme, and the Court of Justice said specifically that that made no difference to the analysis that I'm currently engaged with. But if I may, I'll just conclude as briefly as I can with really what I fear is repeating the same point again and again, which is that each of the points in the process of reasoning adopted by Advocate General Van Gerven in Tenova is applicable just as much to a future effects principle case applying to time limits and legislation as it is to judge-made limitations of this nature. I won't read it out perhaps, but at page 454 at letter G and then at letter H, there is reference made to pension being deferred pay and to the acquisition of entitlement to a pension as from the date of the judgment. Now, the words acquisition, I fear I've forgotten the case that I read it from, but one of the cases on legislation this morning used that very word to describe the key point. And it's Barber, paragraph 44. And also, yes, I think I'm in 10 over, so. Yes, acquisition is mentioned several times in 10 over. At page 455, at the start of paragraph 19, the Advocate General refers to the distinction between the accrual of the pension or the coming into being of pension rights and the pensions falling to be paid for the first time as being important for a proper understanding of what the court means in Barber by reference to the usual language, legal situations which have exhausted all their effects in the past. And he goes on to reject the submission that was made on behalf of some of the colour roll claimants to the effect that legal situations, that in this context, the legal situation has only exhausted all of its effects when people have retired and are starting to receive their pension payments if they get one. And between D and E, he goes on to say that the distinction between the accrual and the falling due of the pension helps to clarify matters, since it's the service itself, and in some cases, so that's a reference to the fact that contributions aren't always made, and in some cases the relevant contributions which give rise to the rights and obligations of the employee and the employer and of the trustees of the pension scheme. It may reasonably be assumed that in using the expression legal situations which have exhausted all their effects in the past, the court had in view situations in which the right to a pension had already been acquired by virtue of periods of service prior to the judgment in Barber. The coming into being of a pension right on the basis of a period of service in the past leads indeed to a legal situation whose effects are exhausted in the sense that the worker has definitively acquired the pension right relating to that period of service. Now, pausing there, that last sentence, in my respectful submission, is the complete answer to the issue in this case. And at paragraph 20, reference is made to legal certainty as underpinning this principle, which again is a principle of law that underpins both the legislation and the judge-made type of exclusion. Then, if I could ask the court to move to page 458, paragraph 22.
What is the right that the worker has definitively acquired at the time when he does the service? Because a great many schemes require, for example, a certain number of years of service before you become entitled. So he hasn't got any rights at all if he's just worked for a few weeks or a few months or even a few years. There are other schemes where you don't have any right unless and until you reach a particular age, and so on and so forth. Now, you cannot say that somebody has actually acquired the right. All you can say is that they fulfilled one of the conditions for acquiring the right.
Yes, my lady, the qualifying period cases, of which Bruno and Pettini is the classic example, are different. If I may, I'll make my submission as to why they are different.
Yes, I'm looking forward to hearing those.
Bruno and Pettini, but in my respectful submission, they are different. What is an issue in this case is a classic pension scheme, where the requirement which gains you your right to the pension is a period of service that you've worked, and you can equate and connect the period of service to the pension.
Well, what about the second scenario that my lady put to you, namely reaching a certain age?
Yes, my lord, in that case still, your right is fixed at the time when you perform your service. Whether it's described as a contingent right or not, in my submission, doesn't really matter, because the fact remains that you have an irreducible right provided you live to a certain age.
Well, provided you fulfil the extra conditions.
Well, indeed so, but
Well, can you be said to have definitively acquired it? Let's suppose you're a single person with no dependents, no relatives, and you've done 20 years in order to acquire the right, but you die at 64 and a half years old, can you be said to have definitively acquired the pension right in those circumstances?
In my submission, applying EU law, yes, because that's the consequence, that's the unavoidable consequence of the reasoning in Tenova in the cases we'll come to see. In a moment, I'll show you colour roll, in which the report for the hearing recognised exactly that point, that you may not live long enough to claim your pension, and nonetheless exactly the same analysis of the approach to when the rights are accrued in the pension context was adopted in colour roll, as has been adopted in Tenova.
The way the court deals with the issue in Tenova, at paragraph 19 on page 488, is differently expressed, and I at least find it much easier to understand. They distinguish between benefits payable in respect of periods of employment that predate Barber and benefits payable in respect of periods of employment which postdate Barber. So you don't get involved in problems about when rights vest. It's rather in respect of what period is the benefit payable.
My Lord, yes. And we'll see, it's perhaps that's the high point of the simplicity of the way that the point is put in any of the case law of the court. But I would respectfully submit that whether we like it or not, this is the analysis that the Court of Justice has adopted, and we're about to see.
It's the Advocate General here.
My Lord.
It's the Advocate General we're looking at on
yes,
page
but I'm
455.
going to come on to submit that the passage that my Lord has just referred to, effectively, although the language is simpler and more elegant, is the same test as was set out in a great deal more detail by the Advocate General.
Non-contributory final salary schemes don't really fit this simple model, do they?
They do if they final salary, because in a final salary scheme, your pension is a function of two things. One is your final salary, and the second is the length of your service.
Well, usually sometimes it's pure correlation between length of service, and sometimes, as in the judicial pension, it's a minimum length of service plus final salary.
Nonetheless, in my respect for submission, there is always a factor which is the period of service. Of course, in theory, there could be a pension scheme which doesn't require any amount of service at all that you qualify for it.
Could be.
Instant you start.
Yes.
Happily, that's not an issue.
We have encountered such an one.
Well, my lady, I haven't, I must confess. And
argued to be such an one, yes.
The court hasn't encountered such a one, but it is dealing with what is deferred pay, because at the very heart of this is the proposition that pension is deferred pay. It's very long deferred pay, but lots of other types of pay, like bonuses, are deferred to a certain extent, and yet the right to that pay is accrued at the time of the period of employment. And that's the simple model that the Court of Justice and the Advocate General, in this case and in others, has adopted to applying the test of when rights are definitively established in the pension context. My lady, my lords, there was only one last passage in Tenova's Advocate General's opinion that I wish to draw to your attention, which is at page 458. And this is where the counter-argument, the exact argument that my learned friend Mr. Allen is advancing before you was considered and rejected. He says, in passing, I would point out that, in my view, the third interpretation, in which it's suggested that the falling due of the pension after 17th of May 1990 should be the decisive criterion, irrespective of the time when the periods of service to which the pension relates were completed, cannot be entertained under any circumstances. I consider this option undesirable, not only in view of the way described above, in which pension rights accrue, but also on account of the clear unfairness to which this interpretation would lead for a large number of workers. Not a single worker whose occupational pension became payable or was paid for the first time before the 17th of May 1990 would then be able to rely on the principle of equal pay. Situations which are otherwise completely the same, but differ only in that they lead to entitlement to payment before or after the 17th of May 1990 would then be treated in a very different way. And that's, I'll come on in a moment to makes submissions about reasons of common sense and logic why I submit that the court's and the Advocate General's opinion is the right one, but the one being focused upon here is that if two people working exactly the same periods of service, then whether or not they qualify for a pension depends entirely upon the date many, many years later when they happen to retire. My lords, my lady, unless you wish me to do so, I won't take you back to the judgment in Tenova, because my Lord Reid took us to the relevant passage. May I take you on, though, very briefly, to three other cases, two of which are in the same line, one of which isn't a Barber case, but is a judge-made case. The first one is Colour Roll, which you'll find in tab 2 of volume 1, beginning at page 68. But if I may, I will take you straight to two passages in the court's judgment, the first beginning at page 115. Colour Roll, as Mr. Allen said this morning, was heard at the same time as Tenova. This was a claim about a pension scheme that took account of actuarial factors in a way that disadvantaged men. But in the course of it, the court considered the scope of the Barber limitation. And at page 115, at paragraph 34, the court says this is the judgment of the court. As regards periods of service prior to the 17th of May 1990, the date of Barber, it is sufficient here to say, as will be explained below, that the Barber judgment excluded application of Article 119 to benefits payable in respect of those periods, so that employers and trustees are not required to ensure equal treatment as far as those benefits are concerned. And then 2 pages on, page 118, this is where they deal directly with the Barber limitation issue. And having referred at paragraph 45 to Tenova, the judgment continues, that ruling took account of the fact that it was characteristic of that form of pay, that is pensions, that there was a time lag between the accrual of entitlement to the pension, which occurred gradually throughout the employee's working life, and its actual payment, which was deferred until a particular age. The court also took into consideration the ways in which occupational pension funds were financed, and thus of the accounting links existing in each individual case between the periodic contributions and the future amounts to be paid. Given the reasons explained in Barber for limiting its effect in time, it had to be made clear that equality of treatment in the matter of occupational pensions could be claimed only in relation to benefits payable in respect of periods of service subsequent to 17th of May 1990. So again, the focus, it's made clear, is upon the accrual of entitlement during your working life, not after. And as regards the point I made in response to a question from my Lord Carr, at page 71 in the report for the hearing from the juge rapporteur, at letter G, the judge pointed out that the essential characteristic of such schemes, as under consideration in Colour Roll, is that their eventual liabilities cannot be known because the pension to be provided on each member's retirement, being related to his earnings near to that date, cannot be known until he or she actually retires. So there was a recognition that although you accrue your pension during the period of service, you don't have a definite entitlement or a definite knowledge of what your entitlement will be until considerably later. The next case, I'm afraid, is in a different file. It's Berner. It's volume 4, tab 59, page 1419.
Johnny, what's that reference again, please?
It's page 1419, my lord, tab 59. This was a case in which one of the issues that arose was whether the statutory scheme for civil servants in the Netherlands was a pension scheme and therefore covered by Article 119, or a state social security scheme, which is covered by a different directive, 79.7. And at paragraph 66, The answer was, I should say, that it was an occupational pension scheme. At page 47, paragraph 66, in the Advocate General's opinion.
Wait, page what?
Page 1437. It's Francis Jacobs. He says, I return to the question whether a claim such as Mr. Berners should be limited, as the Commission suggests, to the part of the pension corresponding to periods of employment subsequent to the date of the Defren judgment. The suggestion may seem at first sight surprising, since the discrimination of which Mr. Berner complains did not start until 1988, when he started to receive his pension. However, it seems to me that the Commission's suggestion is correct. The very basis of Mr. Berner's claim under Article 119 is that his period is deferred pay, and in contrast with the position in Barber, it is a claim based on specific periods of past employment. It would be illogical for claims for deferred pay to relate back indefinitely, and possibly even to a date before the entry into force of the treaty, when claims to non-deferred pay were limited to the date of the ruling, giving direct effect to Article 119. Admittedly, the possible financial consequences which influence the court in Defren have far less force here. Moreover, this temporal limitation introduces a distinction between pension claims based directly on periods of employment and other pension claims which are not so based, which may seem a regrettable complication. Nevertheless, the very logic of treating pensions as falling within Article 119 requires, in my view, that claims based on specific periods of employment should be limited in a way which corresponds to limitations on other claims to equal pay. And in the court's judgment at page 1446, perhaps I just note at 1445, paragraph 57, is where the court says that this is an occupational pension scheme and not a social security scheme. At paragraph 66, the court says, since the protocol on Article 119 is applicable to a scheme such as that governed by the relevant legislation, and since the civil service pension of the kind at issue in the main proceedings is established on the basis of non-discriminatory arrangements regarding rights and respective periods of service after the 1st of January 86, Article 119 may, by virtue of the very terms of that protocol, be properly invoked for the purpose of requiring equal treatment under that scheme only by civil servants entitled to claim a pension who initiated legal proceedings or introduced a claim before the date of Barber, 17th of May 1990, in relation to periods of service before the 1st of January 1986. However, for the latter category of persons, Article 119 cannot be invoked in relation to rights and respect of periods of service before the 8th of April 1976, that's the date of Defren, because it was only on the date of the judgment in Defren 2 that the court recognised that Article 119 could be relied upon directly, but only in relation to future periods of pay. So another example of the same approach being taken to identifying when rights under a pension scheme accrued, but this time in the context of a scheme that, like this one, was a statutory pension scheme.
And the significance of the date of the 1st of January 86, was that in relation to the domestic legislation?
My Lord, I think so. I realised as I was reading that I wasn't going to be able to provide an answer to that question, but I'll ask my colleagues to find an answer and hand it out.
Oh, yes. Yes, one sees it in the judgment paragraph 9 on page 1439.
My Lord is right.
Yeah.
My Lords, my Lady, perhaps I won't take up time taking the court to Magorian, which was going to be my next destination, but Magorian is another example. It is a judge-made case rather than a legislation case, but one in which Defren was the cut-off date rather than Barber. The issue in Magorian, indeed, was whether it was a case relating to differential sex discrimination in relation to the amount of pension benefits you get, which is covered by Barber, or discrimination in relation to access to pension scheme, which is not covered by Barber. And the answer was it was an access case, and therefore it was found that the cut-off was the Defren date. But nonetheless, it's just another example of the court treating what matters as the period of employment, not the date of retirement. My lords, my lady, may I just give the court a signpost of what I propose to do in the hour remaining for me? I'm first going to make some general submissions on the rationale and behind the approach that has been taken in cases such as Tenova, and to deal with the points that my lady and my lord have raised about whether it is right that the rights are fixed at the time when you perform your service. I'm then going to go and deal with the qualifying service case of Bruno and Pettini, and then insofar as there is time left to me, I will deal with Paris and Maruco and Roma, although I recognise that my learned friend Mr. Koppel is also going to be dealing with Paris and Maruco and Roma, and I may allow him to do the heavy lifting, if I may put it that way, and just make some broad submissions in relation to those cases. And then finally, I'll deal with the Lazar case, which my learned friend Mr. Allen raised this morning. So the next thing I'm going to do is deal with what I submit are first principles, not by reference to specific authorities, to support and justify the approach that was taken by the court in cases such as Tenova and the other ones that I've mentioned. And the first submission that I make is that if it is accepted, as it has been, of course, in our domestic case law, Parry and Cleaver, as well as in the Court of Justice in cases such as Bilka Kaufhaus, that pension is deferred pay, it does follow logically in my submission that you accrue your right to pension alongside your right to salary and other benefits whilst your service takes place. The key difference, of course, is that your pension is paid later, but as I mentioned already, it's not unique in that other emoluments, such as bonuses, can become payable months or even years after the service to which they're attributable. But nonetheless, the only reason that the worker gains a right to a pension is because of the service to which the pension is attributable, and it's exactly the same as salary and other benefits in this regard. It follows in our submission that in a case such as this, the act of discrimination to which the claim relates takes place at the time of service. No new act of discrimination takes place at the time of retirement. It's all traced back to the discrimination that took place during the period of service. So, since pension is deferred pay, the consequences of that act of discrimination are deferred, but that doesn't detract in our submission from the proposition that the discrimination takes place when the service carries on.
And just so I understand that, if you take, for example, a situation where after he has retired, the pensioner marries a man who doesn't then qualify for a dependence pension, whereas if he had married a woman, she would. You say that that is not the relevant act of discrimination. It's rather, presumably, the terms of the pension scheme at the time when he is earning it.
My Lord, yes, and that of course, is a much more pertinent issue for the Walker appeal than it is for our appeal.
Yeah, it's just to illustrate the point.
But it does, in my submission, illustrate the point. How my learned friend puts it is that all that happens during service is that you gain a contingent and prospective right to a pension. We say it's more concrete than that it's a fixed right, albeit according to a formula. And the formula has the effect that you don't receive any pension if you die before the retirement age, unless you have a survivor, and there's a survivor's scheme within the pension scheme.
What do you say to the argument that pension isn't simply accrued pay? That's an element of it, but another dimension of it is that you must have accumulated sufficient years in order to qualify for its payment to you.
Yes, in my submission, there are two separate considerations there. One is what we call the reckonable service, the amount of service that counts towards your pension. That is classic Tenova, and that is accrued as your service carries on. If you have a pension scheme that says that you need to be in post for 10 years before you qualify for any pension at all, therefore qualifying service, that's different. And we submit that it's clear on the case law that qualifying service prior to the law coming into force is relevant. But we submit, and I'm sorry to keep the court waiting for this, but if I may, I will deal with it when I deal with Bruno and Pettini. There is nothing illogical about the different approach towards reckonable service and qualifying service. But we do say, as regards qualifying service, that things that happen in terms of or the qualifying period prior to the law coming into force is to be taken into account. And indeed, that's the explanation for why Bruno and Pettini was decided the way that it was.
Well, you're coming on to that.
Yeah, we'll wait with
Yeah, I think we better have. Yes.
eager anticipation.
My Lords, my next point, which flows from my last one. In our submission, it's not necessary, in order for the rights to be permanently fixed, that the full extent of the detriment flowing from the breach is known at the time when the legal effects become permanently fixed. You don't need to know exactly how much you're going to lose, if anything, many years down the line, in order for your rights to be permanently fixed. And of course it's right that you can't quantify the amount of pension that you'll get at the time of your service, because that will depend upon your final salary, depend on whether you live long enough, etc. But nonetheless, in our submission, it's clear that the Court of Justice took account of these factors expressly in colour roll and still came to the view that what mattered, where your rights were accrued, was at the time of service. And in our submission, that's a principled conclusion, because there are very many rights that are accrued at a particular point when you can't yet quantify them. To take a couple of examples, in an ordinary discrimination case, a sex discrimination case relating to dismissal, for example, the rights are accrued at the moment of dismissal, even though you can't quantify the loss, because that will depend upon future events, such as whether you manage to mitigate your loss by getting another job. But nonetheless, the cause of action accrues, and the legal situation becomes permanently fixed at the time of dismissal. And another example, a second example, comes from one of the cases that are mentioned in my learned friend's supplementary note, a case called Van Eetvelt, which was a personal injury case. In that case, the Court of, it was the Advocate General, I should say, used that as an example of where there was an accident, and the rights relating to the accident became permanently fixed at the moment of the accident, even though you couldn't then necessarily know what the financial consequences of the accident were going to be. So yet again, in our submission, it's not a precondition for rights to be permanently fixed that you are able to quantify their full extent. And again, in our submission, a final example, that's the same with the breach of contract claim. A classic wrongful dismissal case, the cause of action accrues when somebody is dismissed, even though, again, you can't necessarily quantify the amount of their loss, because that will depend upon mitigation and whether perhaps the factory would have been closed down in 3 weeks in any event. But nonetheless, the cause of action accrues at the moment when the breach takes place. And in a pensions case...
Sorry, are you saying that there are cases which treat that as being permanently fixed?
Yes, not contract, no, but PI, yes. The accident case is Van Eetvelt.
Which one?
Which is in my learned friend's supplementary note at page 2347. The legal consequences of an accident became permanently fixed at the time of the accident, even though you couldn't quantify the full amount of the loss at that stage.
2347.
That's
2347.
In Mr.
So
Allen's
not in his
supplementary
today's note, but in the supplementary note that was attached to his written case.
So it's part of his written case.
It's a long extract from the Advocate General's opinion in a case called Ullabrith Anderson.
Oh, yes, Anderson.
Oh, it's Anderson, yeah.
Oh, it's on the electronic file. So
It is, my Lord, yes.
Yeah.
2346.
Yeah.
And at page 2, what the Advocate General says is, in Van Eetvelt, the legal situations covered by the directive in question were road accidents. It was therefore rightly held that the relevant time for the purposes of selecting the applicable rule was the time when the road accident took place. That's about 7 or 8 lines down, paragraph 61.
Where do they say permanently fixed?
They don't. What they say is the relevant time for the purpose of selecting the applicable rule was the time when the road accident took place. But this follows on from an explanation for what the rule was as being, this is on page 2345, paragraph 57, that the issue is the application of the rule to situations which were permanently fixed before that rule came into force.
So it's an application of that principle, you say?
Indeed so, my lord. And dealing specifically with the pensions case, it's possible for a tribunal or a court to provide a remedy at the time of service, even though you don't actually lose any money until you retire many years later. And that's because what the tribunal can do is grant a declaration that have the effect of changing the rules of the scheme. And just for the court's note, page 599 in volume 2 of the bundle, it's regulation 8, subsection 7 of the part-time workers regulations. So there's no problem with the cause of action being enforced at the time of service. And indeed, in the very large-scale public sector cases in which Mr. Allen and I have been involved over the last 20 years, including the Preston and Wolverhampton healthcare local government cases and the firefighters cases that Mr. Allen was involved in, that's what happened. The claims were brought and the remedies were obtained long before the vast majority of the claimants had retired. And we submit that by way of a sense check, the court will permit me that horrible expression, but by way of a sense check, a number of strange and illogical consequences would follow if it were otherwise. And we enumerate 6 of them. First, if my learned friends were right, then pension benefits would be treated completely differently from any other type of employment-related benefits. Because discrimination in relation to salary, any other sort of benefits, before the 7th of April 2000 would not be actionable. It would only and uniquely be discrimination in relation to pension that could found a claim in respect to benefits that are attributable to service prior to the 7th of April 2000. Secondly, if my learned friends are right, then a part-time worker who retired after the 7th of April 2000 would be able to claim a pension even in relation to service prior to January 1972, the accession to the European Union, which would mean that employers could be in breach of EU law in respect of a type of pay that was being earned even before the UK joined the EU. Third, if my learned friends are right, then it should follow that you can't claim until you retire because no discrimination happens until you retire. It would mean, actually, that all the claims in these proceedings would be premature and would have to be struck out. And it would also mean, more seriously perhaps, that there'd be no remedy until many years, until after the actual wrong had taken place. Our fourth point is that we submit an illogicality at the heart of my learned friend's submission. Why fix on the date of retirement? If they are right, if their logic is adopted, then the breach is a continuing one that takes place throughout a person's period of retirement. Because throughout your period of retirement, you're not getting paid what you should be paid. It doesn't happen suddenly and completely when you retire. And at the point of retirement, you're not able to quantify the full amount of your loss any more than you are at the point of service. And therefore, we submit, why should it matter whether you retire before or after the year 2000, or if your survivor's still alive after then? I'm sorry, I should put it this way. If you're still alive after the 7th of April 2000, why should it matter when you retired, if my learned friends are right in their argument? The only reason we submit that they've limited themselves in the way that they have is the recognition that it would go too far to follow their argument to the logical conclusion. The fifth point is a point that was made by the Advocate General in Tenova at paragraph 22, page 458, and that is that if they're right, then it would mean that if two people had identical fee-paid judicial careers, say from 1980 to 1990, both went on to the full-time salaried judiciary on the same date in 1990, one happened to retire on the 6th of April 2000, and the other retired on the 8th of April 2000, first one would have no claim at all under the part-time workers regulations, even on the appellant's case, whereas the other one would have a claim for the whole of her or his 10 years of part-time service. And in our respectful submission, that felt wrong and unfair to the Advocate General in Tenova, quite rightly, because the acts of discrimination in those cases took place at the same time when the service took place, and so it shouldn't make any sense at all that the right to claim should depend upon a factor that's irrelevant to the discrimination that they suffered, the date on which they happened to retire. And sixth and finally, a point that is emphasised in Tenova and indeed in Barber, it would have a very serious effect on pension schemes if you discovered many years after the event that you were liable for something that wasn't against the law at the time when you were collecting your contributions or making your own employer's contributions. And as regards the Miller case, the time limit case, my learned friends say that this rule, as we say it is harsh and chilling. But in our submission it isn't. It's entirely logical. It's just wholly consistent with the usual principle that time runs from the end of your period of employment, the period when the damage is being done, and that should apply to judges as it should apply to everybody else. There's no basis in our submission for special pleading for judges. And my learned friend referred this morning to the Kapoor case, the House of Lords case about those who'd been expelled from Uganda because they were Asians and who had taken jobs with Barclays Bank. The point about the Kapoor case in my submission is this, that the wrong that happened to the individuals in Kapoor was that they had a contract of employment in England that didn't credit them with their earlier service in Uganda. And the way that the House of Lords analysed the case was that the breach was a continuing breach throughout the period of their employment. That's wholly consistent with our argument, because we accept that the breach is a continuing breach up until the end of the particular period of fee-paid service. So, in our respectful submission, the test that is laid down in Tenova is, as it was put in a question this morning, a universal rule. It's not something that's particular to the Barber type case. It's a rule that applies across the board to legislation cases as to Barber type cases, because in both cases, the future effects principle has exactly the same meaning and exactly the same application. And if we're right about that, then Tenova and its the cases that follow does indeed provide a ruling of the court on this very issue, and therefore there is no need for a reference. May I just, I'm sure the court is not in any doubt about this, but since it's been raised, may I mention that we're not inviting you to make a Barber limitation in this case. A Barber is only the occasion, it's only the context in which the analysis in Tenova was carried out. But this is a legislation case, not a case law case, as was the position in Barber. My lords and my lady, I'm now finally going to move on to the Bruno and Pettini case and the issue of the distinction between qualifying service and what we've called reckonable service. And may I start by making a submission as to why those two things are different, before then coming on to show you why Bruno and Pettini is an example of qualifying service rather than reckonable service. In our submission, the reason that you take qualifying service into account, the number of years, the precondition before you get any pension entitlements, is that otherwise the case would offend against the future effects principle, because it would mean you would have to start again with the qualifying period when the new law came into force, and that would postpone implementation of the rights by many years in some cases, and it would also mean different start dates for different workers, according to how much qualifying period a particular pension scheme provided for. It is, in other words, I'm forgiven the colloquialism, it's to ensure that the new law hits the ground running. It's to ensure that as soon as the law comes into force, it's applicable. But it doesn't mean that service, actual service, prior to that date counts towards reckoning your pension. And I've come up with an example from outside the pensions field to try and illustrate what I mean. And it's this. Say that a business has a term in its employees' contracts that you qualify for a company car after 5 years of employment, but only those over the age of 40 get a company car. That would have been rendered unlawful by the age discrimination provisions of the Equalities Directive in about 2003. And that means that a person who's under 40 with more than 5 years service can claim in relation to this breach from the date of implementation in 2003 onwards. They don't have to wait for another 5 years of qualifying service. So the period of service prior to the implementation date can count towards the qualifying service. But at the same time, that person can't claim for the fact that she or he didn't have a company car in the period prior to 2003, even if they'd already acquired the 5 years qualifying service and hadn't got their company car.
Can a period of service be both qualifying and reckonable?
Yes. Yes, as it is under JUPRA, as my learned friends, and as it normally will be, because normally retrospectively you're then credited with the period of service that you've had, not always, but often.
Well, is your submission that if it partakes of reckonable service at all, even though it may also qualify for the description qualifying, that it's to be left out of account?
Absolutely, because there are two different things. They're two different. One's an entitlement, one is a precondition to an entitlement. The entitlement itself, the benefit, I'm sorry, I should put it this way, one is a benefit, one is a qualifying provision that's a precondition to the benefit. As for the benefit itself, you only get it from the day when the law comes into force. As for the qualifying condition for the benefit, you can take into account the facts, the position prior to the date of the law coming into force. So to use my example of the company car again, somebody who didn't get his company car but should have got it prior to 2003 doesn't have a claim in the period prior to 2003 because the position in relation to the company car is permanently fixed. The rights were definitively established prior to 2003. But the qualifying period, it's different. Qualifying periods can be taken into account. And as my learned friend Mr. Bourne puts it, your pension is pay for your reckonable service. It's not pay for your qualifying service. And there's another, what I hope is helpful, example of how qualifying periods work in EU law amongst the authorities, which is a case called Filev, which you will find in, I think it's volume 6, it's tab 91, page 2119. Sorry, I'm wrong. No, I'm right. It is tab 6.
Sorry, say that again.
Volume 6, tab 91, starting at page 2119. It's not a pensions case. This was a case about German legislation that provided for an entry ban. If you were expelled from Germany as a foreign national who committed a crime. You were expelled and you weren't allowed back in for 5 years. And there were criminal sanctions that were imposed upon you if you re-entered. So Mr. Filev was told to leave Germany in 1992. He was actually given a lifetime ban. But he tried to get back into the country in 2012, which was after the directive that rendered this law unlawful came into force, Directive 2008-115. And the reason the German law was unlawful was the directive imposed a cap of 5 years for the entry ban. So Mr. Filev was expelled. The new legislation, new EU legislation, came into force on Christmas Eve 2010, and the question arose whether that meant he had to wait another 5 years before he could come back, or whether he could come back straight away, because more than 5 years had elapsed since he was expelled. And the Court of Justice said he could come back straight away, and that's because the qualifying period, in this case in a different context, it's still a qualifying period, because the qualifying period can take account of periods before the EU law comes into force. And just in the court's judgment, may I show you that, paragraphs 37 and following, which is at page 2124. It follows that a member state may not impose criminal sanctions for breach of an entry ban, falling within the scope of the relevant directive if the continuation of the effects of that ban doesn't comply with the article which says that it must be for no more than 5 years. It's therefore appropriate to examine, having regard to the circumstances of the case in the main proceedings, whether this precludes the continuation of the effects of entry bans of unlimited length, which were decided before the date by which the member state concerned should have implemented the directive, beyond the maximum length of such a ban laid down by that provision, which is 5 years. In that regard, it's important to note from the outset that that directive does not include a provision providing for transitional arrangements in relation to entry ban decisions taken before it came apart. Nonetheless, it follows from the court's settled case law that new rules apply immediately to the future effects of a situation which arose under the old rules, and some of our old friends' cases are referred to there. It follows that the directive is applicable to those effects which occur after the date of its applicability in the member state concerned of entry ban decisions taken under national rules which were applicable before that date. And as I understand the judgment, what that means is that Mr. Filev didn't have to wait 5 years before he could return to Germany because the qualifying period was taken into account even though that period took place prior to the date on which the EU law came into force. So, in our respectful submission, there is a clear distinction in EU law between reckonable service and qualifying periods in the pensions context. And this finally brings me on to Bruno and Pettini itself. Bruno and Pettini is in tab 3, starting at page 127. And if I can summarise the facts, it was an odd case because it wasn't a discrimination against part-time workers as compared to full-time workers. It was discrimination between two different types of part-time workers. One lot who were called horizontal part-time workers, which is those who worked some days a week but not all days a week, and people called vertical part-time workers, who were people who worked all of some weeks and none of other weeks. I assume, though I don't know, that the vertical part-time workers would be women with childcare responsibilities who had term-time only contracts. But in any event, they were both part-timers. They both did roughly the same number of days a year, but they were organised differently. And there was a rule under this slightly surprising Italian pension scheme that you needed to have accrued a certain number of weeks' service, or weeks in which you did some service, in order to qualify for your pension. The way that it worked was that if you were a horizontal part-time worker, then you stood a chance of getting into the pension scheme, albeit you'd have to do about 35 years of part-time work to get into the pension scheme. If you're a vertical part-time worker, in practice you stood no chance of getting into the pension scheme because, as we'll see, you would need to have worked for 70 years in employment before you qualified for your pension scheme. So in this case, the issue was qualifying service. It said in terms, in the Advocate General's opinion, that once you get over the qualifying service hurdle, there is no problem with the amount of pension you get. There's no problem with reckonable service. The problem is qualifying to get into the pension scheme in the first place. So can I take you first to paragraph 95 of Advocate General Sharpston's opinion at page 147. The unequal treatment appears to arise from the manner in which qualifying weeks are calculated, which directly determines how long it will take for workers to gain access to a pension, because only weeks in which work was performed during at least one day count as qualifying weeks. For an equal number of hours worked, vertical cyclical part-time workers may end up having to work twice as long as horizontal part-time workers to gain access to their pension. In my example, the horizontal part-time worker would have to work 35 years to gain access to a pension, while the vertical cyclical part-time worker would have to work 70 years. If that person spent his whole career working on a vertical cyclical part-time basis, he would be unlikely ever to qualify for a pension. So that's what the problem was. The problem was a qualifying period. And at paragraph 91, the Advocate General makes clear that there's no problem with reckonable service. Excuse me. She says, in essence, the criterion for calculating the amount of the pension seems to be that the number of hours worked is taken into account in the same way, regardless of whether the work was done under a full-time, horizontal or vertical part-time schedule. In its written observations, the company states that in order to determine the duration of the contributions to be taken into account for the calculation of the pension, it's necessary, and then it sets out the formula. And in the last sentence, she says that method for calculating the amount of the pension does not, it seems to me, generate a different result depending on whether the part-time work involved was vertical, cyclical, or horizontal. And at para 93, she says, the problem, as INPS admitted at the hearing, seems to lie in the calculation of the number of weeks necessary to gain access to a pension, qualifying weeks. Counsel for INPS explained that in order to gain access to a pension, 1,820 qualifying weeks are necessary. And the qualifying week is defined as a week in which work is performed on at least one day. So this was all about qualifying periods, which explains, in my respectful submission, why there's no consideration of turnover or colour roll or any of the cases in that line of territory in the Bruno and Pettini case. This is a classic application of the orthodox future effects principle, which, as in Filev and as in my company car example, allows you to take into account qualifying periods that take place prior to the law coming into force. Similarly, the Court of Justice itself made clear that what it was concerned with was qualifying periods. So just to take a few examples, at page 157, paragraph 20. In the present case, the disputes in the main proceedings concern whether the methods of calculating the period of service required to qualify for retirement pension rights for workers who've opted for a certain type of part-time work discriminates against such workers. And again, at paragraph 52, which is on page 160, there's reference to the issue being the calculation of the period of service required to qualify for a pension, for a retirement pension. And then at 53, there is reference to some of the leading authorities, including one of the ones, or two of the ones I showed to you, the Freistaat Saxon and the Centeno Mediavilla case. So the court was completely conscious and aware of the future effects principle. It just didn't have to deal with 10 over because that issue didn't arise. And then at paragraph 55, the court says the calculation of the period of service required to qualify for retirement pension is governed by the directive, including periods of employment before the directive entered into force. So I'm sorry if I've made a bit of a meal of this, but the simple point about Bruno and Pettini in my submission is that it was concerned with a completely different issue from the issue that arises in our case and the issue that arises in Tenova. It's a case about qualifying periods, not a case about reckonable service. And my learned friend's written case says that there's no suggestion in the court's judgment that it was aware of the difference between qualifying service and reckonable service. Now, it's right that the court doesn't actually use the word reckonable service, but in our submission, it's equally clear that the court was aware of the difference because paragraph 65 and 66 on page 162 deal separately with reckonable service, the amount of the pension, which is dealt with at paragraph 65, and then with the period required to acquire pension rights, qualifying service, which is dealt with at paragraph 66. So in our respectful submission, the court was well aware in this case of the difference between qualifying service and reckonable service, although, as we've confessed, the word reckonable is something that one doesn't actually find in the judgment. So in our submission, there's nothing in Bruno and Pettini that should give one any pause for concern that Tenova is not applicable to a case like this.
Would a change in the rule, in the law, which had the effect, as here, of bringing into useful operation pre-change qualifying service, might it have the same sort of effect on the funding of a pension scheme as a change in the rules for reckonable service?
Yes, it might. Nonetheless, the court...
Nonetheless, you say there's a difference.
There's a difference.
Right.
And the reason for the difference is my hit the ground running point. If it were not so, then you would delay for very long periods of time.
Yes, I follow that.
The implementation of the legislation. So in this case, in my submission as regards qualifying service, legal certainty matters more than the financial consequences.
Yeah.
My lady, my lords, may I move on to Paris and Morocco? And as I've said, my learned friend, Mr. Koppel, will no doubt deal with this in greater detail, but may I give the court a headline sketch of what we say is the reason why these cases, again, don't assist my learned friend in any way at all. Now, there is nothing in the reasoning of or indeed the outcome of the court's judgment in Paris that my learned friends can rely upon at all. They fairly and frankly accept that. Rather, the best they can do is rely upon a short passage in the Advocate General's opinion relating to a matter that turned out to be irrelevant in light of the court's ruling. And within that passage, they refer to sentences in which all the Advocate General purports to do is to describe what was found by the court in the earlier cases of Morocco and Roma. In our respectful submission, she just got it wrong in relation to one particular aspect of the Morocco and Roma judgments. But it doesn't matter, it didn't matter in the end for Paris. As my learned friend said this morning, it's the judgment that determines the outcome, not the Advocate General's opinion. But in any event, what it didn't do is grapple with Tenova, let alone purport to depart from and set aside the reasoning in Tenova and the long line of cases that came after. So the purpose of my brief review of Morocco, Roma and Paris is to show you that those cases don't actually help at all in relation to this case. I'm sorry, my lady.
All right. Yeah.
Morocco. Maruco dealt with two issues, neither of which arises in or is relevant to the present case. The principal issue in Maruco was whether the Equalities Directive precluded discrimination in relation to survivors' pensions to same-sex couples who had entered into a civil partnership. And associated with that, the court considered the point in time at which that became unlawful, that type of discrimination became unlawful, because the court said that that type of discrimination was unlawful. Then, having reached that conclusion, the court was asked whether it should impose a Barber-type limitation on its conclusion. The reason the court was being asked that was that the court's decision departed from an earlier, at least one earlier judgment of the court in Grant and South West Trains. So the argument was employers would have been fooled by Grant and South West Trains into thinking that you can discriminate against same-sex couples with civil partnerships. Now it turns out you can't, so please grant a Barber limitation. The court wouldn't do so, not least because the court also found that the point at which this type of treatment became unlawful was only when the member state had chosen to grant a status akin to marriage to same-sex couples. So it wasn't going long back into the distance as it was in Barber. The case is made somewhat more difficult to follow because the referring court didn't ask the question, should there be a Barber-type limitation? They said, should there be a Barber limitation, by reference to May 1990. And Barber, of course, was a sex discrimination case. May 1990 had absolutely nothing to do with sexual orientation discrimination, but the court, sensibly, if I may say so, picked up the question and treated it as it was obviously meant to be, as a question whether there should be a limitation akin to Barber in the Maruco circumstances, and the court's answer was no. But those are the only two things that Maruco decides. What Maruco didn't do was conduct a turnover analysis. In Maruco, the court said it is unlawful to discriminate against same-sex couples in a civil partnership from a point at which your domestic legislation allows same-sex couples to have a civil partnership akin to marriage. It didn't go on to say, and that means, in a pensions case, service only from that date onwards is taken into account. Just doesn't deal with that. And we submit there's a very good reason why it doesn't deal with that, which is that it didn't need to, because turnover and colour roll provide the answer to what the application of the cut-off is in the legislative cut-off is in a case relating to pensions. So that is a very whistle-stop tour of my submission on Maruco. Can I just show you a couple of paragraphs in the judgment itself? You'll find it in tab 7 in volume 1, beginning at page 212. Judgment at paragraph 61 at page 287. Addresses the particular, or one of the particular questions that was addressed to the court, which is whether survivors' benefits in relation to same-sex partnerships come within the scope of the Equalities Directive at all. And the answer was yes. And at paragraph 73 on the next page, 288, having dealt with consideration of the matter, the court says, follows from the foregoing that the answer to the third question must be that the combined provisions of the Equalities Directive preclude legislation such as that at issue in the main proceedings, under which, after the death of his life partner, the surviving partner does not receive a survivor's benefit equivalent to that granted to a surviving spouse, even though under national law, life partnership places persons of the same sex in a situation comparable to that of spouses as far as concerns that survivor's benefit. It is for the referring court to determine whether a surviving life partner is in a situation comparable to that of a spouse who is entitled to the survivor's benefit, provided for under the occupational pension scheme managed by the German authority concerned. So it's for the national court to decide the point at which domestic law recognises a relationship that is equivalent to a civil partnership. And that's made all the clearer, perhaps, at page 275 in the Advocate General's opinion at paragraph 100. It is therefore necessary to establish whether those two types of union warrant equal treatment, for which purpose the national court must determine whether the legal situation of spouses is akin to that of persons in a registered civil partnership. In the event that it's not, criteria for comparison would not be valid. Now, in the judgment itself, at paragraph 23, I think. Yes, at paragraph 23 on page 281. The court refers to the development in German law relating to life partners, which was the word for same-sex civil partnerships, and how similar they were to spouses. As I say, what there isn't in this case is any consideration of the question of the turnover issue, where you have a pension scheme, whether it's at the time of service that matters or the time of receiving your pension, because that issue just didn't need to be dealt with. There was, however, a reference to turnover by the court, paragraph 44 on page 285, on a different issue, completely different issue, which is that pension entitlements are paid, but it shows that the court was aware of the existence of the turnover line of authority. The other issue that was addressed in in Maruco, is what's called the fifth question, and that can be seen at page 289, starting at paragraph 74. The referring court wanted to know whether in the event that the court were to rule that the directive applied, entitlement to the survivor's benefit at issue in the main proceedings must be restricted in time, and in particular to periods subsequent to 17th of May 1990 on the basis of the case law in Barber. As I respectfully submit, the reference to Barber made no sense at all, because Barber's about sex discrimination. Not
or the 17th of May 1990.
No, indeed, because that's the date of Barber.
Yeah.
But nonetheless, the thrust of the question was interpreted by the court to mean should there be a similar limitation in this case.
Yeah.
And the court said at 77, it's clear from the case law that the court may exceptionally, taking account of the serious difficulties which its judgment may create as regard events in the past, be moved to restrict the possibility for all persons concerned of relying on the interpretation which the court gives to a provision in response to a reference for a ruling. A restriction of that kind may be permitted only by the court in the actual judgment. See Barber and other cases. There's nothing in the documents before the court to suggest that the financial balance of the scheme is likely to be retroactively disturbed if the effects of this judgment are not restricted in time. Therefore, there's no need to restrict the effects of this judgment in time.
Well, how far back did it go then?
It went back, I think, to 2005.
Well, in 76, they referred to the Commission's argument that it didn't come into force until the 1st of August 2001. The German legislature from the 1st of January 2005. So it went back, you say, to the date of the coming into force of the German legislation.
Yes, because the precondition for this being unlawful under the directive is that the domestic member state has a status of marriage or akin to marriage for those who are in same-sex couples. And they referred back to the German court to decide exactly when that happened. But it appears from paragraph 76 that the Court of Justice thought it was around about 2005. So, in a sense, I've spent 10 minutes on Maruco to make a single submission. Maruco is of no relevance to us, and certainly is no authority that undermines the propositions upon which we rely. The case of Roma, I will deal with very briefly indeed, if I may. It's at tab 12, which is, I'm afraid, in the next file. It's another German case, another same-sex couple case, but the point about Roma is that the type of discrimination was taxation on retirement pensions. It wasn't about the amount of pension you gained by way of service at all. Sorry, my lady, it's page 380 is where the judgment starts. And so actually this was a case which wasn't really a case about discrimination in terms of your pension entitlements. It's a case about discrimination in terms of the taxation that was imposed once you've retired on the pension in your hands. Now, as it happened, the employer was the local authority that also did the taxing. So they did a bit of PAYE, so to speak, and they gave a net pension to those who were pensioners. But it's a completely different factual situation from the type that arises in our case. It was a case of discrimination at the point of payment. And the main issue in Roma, which was before the Grand Chamber, was whether discrimination against those who were in civil partnerships, as compared to married couples, became unlawful only when the Equalities Directive came into force, and indeed later than that, or whether it was unlawful even earlier than that because it was contrary to a general principle of equality in EU law. And the court said that it couldn't become unlawful until the directive came into force, and even then it was only unlawful at the point when the member state changed its law so as to provide for something akin to marriage for same-sex couples. Paragraph 64 of the judgment, page 419, is where the court rejects the proposition as a general principle of EU law. There was, again, a request for a barber limitation. The question is at page 414. Question 5b was about whether it was unlawful even before the directive came into force, and question 6 is if that question's answered in the affirmative, is it subject to the qualification in accordance with Barber that the calculation of the pension entitlement is to be applied only in respect of that proportion of pension entitlement earned by the pensioner in the period from 17th of May 1990. Now, the word earned there shows that the question actually assumed turnover is right, and it's the period of service that matters, the point when you're earning the entitlement. The court dealt with the point relatively briefly because it hadn't, in fact, found that potentially the claim could go back long into the distance. And at paragraph 66, the court said, as regards question 6, it's sufficient to say that the dispute in the main proceedings relates to entitlement to a supplementary pension paid from the 1st of November 2001, on which Barber cannot have any bearing, notwithstanding the fact that the contributions underpinning the entitlement had been paid before the date of that judgment. And nobody was suggesting that there should be a limitation in time. So the court was simply giving short shrift to the proposition that there should be a Barber-type limitation in that case. The reason I've taken some time on these authorities is to get to Paris, and in particular to spend my last just under 10 minutes dealing with the passage in Paris that my learned friend, Mr. Allen, relies upon. Paris, which is in volume 1, towards the end of Volume 1, was a case relating to sexual orientation discrimination and survivors' benefits. The chronology is set out in the court's judgment at paragraph 16 to 25, page 297 to 298. But it's briefly this. Mr. Paris had a pension scheme which provided for survivors' benefits only if you got married before the age of 60. Mr. Paris turned 60 on the 21st of April 2006. In 2009, he entered a UK civil partnership. On the 17th of October 2010, he applied for recognition of the survivor's right. He then retired on the 31st of October 2010, and civil partnerships were recognised in Ireland on the 21st of January 2011. What the court decided was that the fact that civil partnerships were not recognised in the Republic of Ireland until the 21st of January 2011 meant that this type of treatment wasn't unlawful till then, and therefore Mr. Paris had no claim. The Advocate General took a different view. She took the view that the type of treatment was unlawful from 2003 onwards, and that led her to consider issues that actually she didn't need to consider at all. So there's nothing in the court's judgment that my learned friends can rely upon. There is nothing in the ruling of the court or the conclusions reached by the court that are of any help, but they rely upon a particular passage of the Advocate General's opinion, which is at paragraphs 36 to 43. Sorry, forgive me. Which is... Thank you. It's page 315 indeed. And the point about this passage is that when you look at it, the passages that my learned friend relies upon all refer back and purport to be statements of what was decided in Maruco and Roma, and that's not the case at all, at least to some respects. But if one takes it paragraph by paragraph, 36 simply states the obvious. 37 says that his application was made more than 6 years after the time limit for transposing the directive applied. And if the Advocate General was right, then 7 years of Dr. Paris's service took place after the law had come into force. She says that application is thus covered by the directive and is also any survivor's pension that may be payable in future to Dr. Paris's partner. Now, if all that is saying is that at least some of his service is brought within the scope of the directive, then on the premise that the Advocate General is right, which isn't correct, she would be right. She then says the UK raises the objection that Dr. Paris's pension entitlements were based almost entirely on periods of service completed prior to the entry of the directive and cannot therefore be subject to the principle of equal treatment under that directive. But that objection is unfounded. It's settled case law that a new rule of law applies from the entry into force of the Act introducing it, doesn't apply to legal situations that have arisen and become definitive under the old law. It does apply to future effects and to new legal situations. Otherwise, it's only if the new rule is accompanied by special provisions which provide for retroactivity. Now, that paragraph is absolutely orthodox description of the future effects principle. So the fact that the employment relationship existed before 2003 wouldn't of itself prevent Dr. Paris from having a claim in relation to his service after 2003. Then paragraph 40. Those principles also apply to the temporal application of the directive. A restriction of the temporal scope of that directive, in derogation from the general principles, would have required an express stipulation to that effect in the EU legislature. No such stipulation has been made. Again, that's absolutely right. There's no express retroactivity statement. Here we hit a hurdle. Consequently, the court has already declared that the directive to be applicable to cases concerning occupational survivor schemes, the entitlements under which had arisen long before the entry into force of that directive, and any contributions or reference periods in respect of which also predated the entry into force of that directive. And that's supposed to be describing what the court has done. Footnote 19 refers to Maruco and Roma. I don't have time to take you to the paragraphs of Maruco and Roma themselves, but paragraphs in Maruco, she refers to 3 paragraphs, 19 and 20, which simply refer to the chronology in Maruco, and paragraph 79, which is the paragraph in which the court says, in the Barber context, there is no need to restrict the effects of this judgment in time. So the point is that the Advocate General has mixed up what the court was saying in Maruco. All they were saying is, this isn't an appropriate case for a Barber-type limitation. She wasn't saying, you can, and the court wasn't saying in Maruco, you can go all the way back to the 1959 or whenever your employment started and claim a pension in relation to that. She has failed to note that para 79 of Maruco deals with the Barber argument. It's not saying that in Mr. Maruco's specific case, he can claim all the way back to the word go. And Roma, same thing. She refers to paragraph 66 of Roma, which is the paragraph dealing with the Barber point. So she has, with great respect, simply misunderstood what Maruco and Roma said, doesn't purport to be making any new law herself. She's just repeating what the court said. Then she goes on in the next 2 sentences correctly to say that the court in those cases didn't apply a temporal restriction in Maruco and Roma. And 42, she says it's true that the court has held that the prohibition on discrimination contained in the Equalities Directive can't give rise to claims for payments in respect of periods in the past that predate the time limit for transposing that directive. Well, absolutely so. That's our case entirely. Her footnote, somewhat surprisingly, is Roma. Then she says, however, the recognition of the right to a future survivor's pension at issue in the present case is unaffected by that principle because such recognition is concerned only with future pension scheme payments, even though the calculation of those payments is based on periods of service completed or contributions made in the past. Footnote 23 is a reference again to Roma, paragraph 66, which isn't authority for that proposition at all. It's actually dealing with whether or not there should be a Barber-type limitation in the specific facts of Roma. So with great respect to the Advocate General, all that's happened here is that she has asserted that certain these authorities are authority for 2 propositions, one proposition that they're not authority for at all. My lady, I see that I'm run out of time, or almost.
Just about, yes.
The Lazar case I haven't dealt with. The point about Lazar is that the time limit issue simply wasn't raised by the court. That was the case about somebody who had claiming a pension not in relation to past service, but in relation to a period when he was at school, strangely, weirdly enough, under the age of 18 or when he was doing an apprenticeship.
Well, he was paying contributions and he was doing an apprenticeship, wasn't he?
Yes, I'm sorry, it's the other one. Felber is the one who was still at school and paying pension contributions, which is both prescient and rather odd.
Very wise, surely.
Extremely wise, my lord. I don't for a moment. I wish I had his wisdom, but I certainly don't. But the point is, that there is no debate, as my learned friend accepted in Lazar and Felber, about these issues. The point simply wasn't raised and therefore wasn't dealt with. May I just check with my learned friends if there's anything I've missed? Yes. My learned friend, Mr. Bourne, reminds me that you'll find at page 2369 a more detailed review of what we say about Lazar and Felber than I've been able to give orally. So, my lady, my lords, unless I can assist the court further, those are submissions.
Thank you very much indeed, Mr. Kavanagh, and I take it, Mr. Bourne, you don't wish to follow.
No, thank you, my lady.
Could I just say, Mr. Kavanagh, I don't want to keep you on your feet any longer, but I have to confess I'm not sure I understand the first sentence of paragraph 66 of Roma, but perhaps Mr. Coppell will be able to deal with that when the time comes.
My lord, I'm sure he will. In any event, I will speak to him between now and when he's on his feet, so you'll have the benefit, if that's the right word, of our joint thoughts on the matter.
Thank you very much.
Thank you. Yes. Mr. Chamberlain.
My Lady, my Lords, the appellant in the second case, Mr. Walker, has lived with a man who is now his husband since 1993. They became civil partners in 2005, as soon as that was possible, and they married in April 2014, about 2 weeks after the coming into force of the Marriage Same-Sex Couples Act 2013. Over 23 years of service with Innospec from 1980 to 2003, Mr. Walker accrued the right to a substantial pension. Under the terms of the scheme, he is not the only person capable of acquiring rights to pension. A person who becomes his spouse also acquires a right to a pension on becoming his spouse, conditional, of course, on being still alive at the point where Mr. Walker dies. The marriage does not have to have taken place during the period of service when the pension was earned. Indeed, the date of the marriage doesn't matter at all. The only thing that matters is that the person claiming the pension is, at the time of death, a spouse. Now, it's common ground that at the time of contracting, spouse for these purposes would have meant a spouse of the opposite sex. And the Marriage Same-Sex Couples Act expressly does not alter the effect of any private legal instrument made before it came into effect. The consequence of this is also common ground. Mr. Walker has an undisputed contractual right to a spouse's pension. There's no dispute about the existence of the right or indeed about the amount of the pension. But in order to enable anyone to derive any benefit from that right, he would have to divorce his husband and marry a woman.
But he could acquire that by taking that extreme step.
He could, yes. He would be fully entitled to the full amount, the undisputed full amount of the spouse's pension by taking that step.
I suppose more strictly, any woman he married would acquire the right.
My Lord is exactly right.
Yeah. But anyway, same point.
She would then be entitled, on his death, to a pension worth something in the order of £45,000 per annum. But the only benefit his husband can derive from this entitlement is, on current figures, about £1,000 per annum, which is the statutory guaranteed minimum. And that is roughly 2% of the sum that would be paid to any woman he might have chosen or might in the future choose to marry. We understand it to be agreed that this state of affairs would constitute sexual orientation discrimination against Mr. Walker and his husband, but for paragraph 18 of Schedule 9 to the Equality Act 2010. Now, your Ladyship and your Lordships will have seen that there was some dispute in the courts below about whether that was direct or indirect discrimination. We say it is obviously, I know my lady has been involved in a case dealing with precisely this issue only a couple of weeks ago, but we say it is obviously direct discrimination. Innospec have chosen to treat Mr. Walker, because of his sexual orientation, less favourably than they would treat a comparable heterosexual married man. But in any event, the Employment Tribunal and the Employment Appeal Tribunal made findings of both direct and unjustified indirect discrimination, and the latter were not appealed to the Court of Appeal.
But that's more puzzling, because usually direct and indirect discrimination are mutually exclusive.
I agree. And that's why I say there is a simple answer to this case. This is a case of direct discrimination. There are two people who are in exactly the same position. Their circumstances are identical. The only difference between them is that in one case, the couple is a same-sex couple. In the other case, the couple is an opposite-sex couple.
And what's the criterion being used to distinguish between them? Their sexual orientation.
The lady has the point. It's a clear and obvious case of direct discrimination. As I've said, paragraph 18 of Schedule 9 creates a general exception to Part 5, the part of the Equality Act that deals with work. It exempts from the prohibitions in Part 5, so far as relating to sexual orientation, anything which prevents or restricts a person who is not in an opposite-sex marriage from having access to a benefit, facility or service if A, the right to it accrued before the 5th of December 2004, when the Civil Partnership Act came into force, or B, it is payable in respect of periods of service before that date. I'll give you the reference to that. That's Authorities Bundle 2, tab 21, MS 583.
It's in your case as well, isn't it?
It is. Lady and Lords, the spouse's pension to which Mr. Walker is entitled is payable in respect of a period of service entirely before 5th of December 2004. So on the face of the domestic legislation, paragraph 18 bars his discrimination claim. The question in this case is whether either EU law or the ECHR, or both, provide a remedy. We say the answer is that both do. I'd like, with your ladyship's and your lordship's permission, to make submissions under 6 heads. First, the forward-looking nature of this claim. This is not a complaint, picking up a question that my Lord Reid put to my learned friend, about the terms on which Mr. Walker accrued the right to a spouse's pension. It is a claim about the respondent's failure, once he had acquired a status equivalent to that of a married man, to confirm that he would in the future benefit from the pension that he had earned on a non-discriminatory basis. I can unpack that a little bit. This is an entitlement that Mr. Walker had on any view and has indeed earned. There is no question at all that he is entitled to it if he satisfies the relevant conditions. The question is whether he is entitled, or rather whether his spouse is entitled, access, as my Lord Hughes corrected me just a moment ago, whether his spouse is entitled to access that benefit on non-discriminatory terms.
Well, I wonder, is it a benefit exclusively for the spouse? I mean, if one is in employment earning prospectively a pension, and in the knowledge that in the event of one's death, one's spouse is going to have entitlement to at least a percentage of that, that's something that is individual to you, I should think, as well as to your spouse.
Well, my Lord, I would certainly accept that one has an interest in it. And indeed, the discrimination complaint has been brought by Mr. Walker, not by his spouse, so I'd certainly accept that. But the person who acquires the right to receive the benefit is the spouse.
Yeah.
And indeed, if there is never a spouse, as in many cases there never will be, then no one will ever acquire the right to receive the benefit. So one can look at it in that way. But I certainly agree that Mr. Walker had a proper interest in bringing this discrimination complaint, notwithstanding the fact that it was his spouse and not he who will stand to receive the benefit if this claim succeeds. So the second head,
Did he pay extra contributions for dependents' benefits? Quite a lot of schemes do have, you can choose whether or not to buy in.
I will check that point. I think that the answer is that the scheme required one to pay contributions that would give rise to this benefit. So I'm not sure there was an option to opt out, but I'll correct that if I'm wrong. The second head, it deals with Maruco and Roma and how the courts below misunderstood them. But essentially, lady, we will say that Advocate General Cocotte understood those cases precisely accurately. They show exactly what she says they show. They were both complaints about discrimination on grounds of sexual orientation in pension provision. In both, the service to which the pension related predated 2003. In both, the Court of Justice held that, subject to the issue of comparability, which was of course an issue for the National Court, the claimants were entitled in principle to pension payments, pension benefits, payable from 2003 onwards, notwithstanding that the service to which the pension related entirely or almost entirely predated that date. And in both, the German courts, which had initially referred the cases, held that the claimants were entitled to compensation, even though, if the respondents were correct in their analysis, they should have been entitled to either nothing at all or almost nothing. Third, there is Paris. The questions referred by the Irish court, as you know, did not include the ones that we are dealing with here, but, and this is important when one bears in mind the way the submissions that have been made about this case by Mr. Kavanagh just now, the UK government intervened in Paris specifically to put the very argument that is being put in this case. That was the purpose of the intervention. It wasn't raised by the questions that had been referred by the Irish court, but the UK government came in to put the argument that you're now hearing. Advocate General Cocotte rejected it for precisely the reasons we give, and the Court of Justice didn't deal with the point. They found against Dr. Paris, but only because, under the terms of his scheme, in order to be entitled to a spouse's pension, you had to be married by the time you were 60, and Dr. Paris wasn't. Mr. Walker's case is fundamentally different because under his scheme, the benefit is payable irrespective of the date of the marriage. He doesn't have to have been married at any time. The only thing that counts under his scheme is that he is married at the time of his death. Fourth, the obligation to disapply paragraph 18 under the doctrine in Kuchuk-Devici, which is another decision of the Court of Justice. It's been applied by this court and explained by this court in the case of Chester, but essentially it has the effect that if paragraph 18 is indeed contrary to the directive, then notwithstanding that this claim is brought against a private entity, Innospec, paragraph 18 must still be disapplied because it's contrary to a general principle of EU law. Fifth is the question of a reference to the Court of Justice. We say that even if Mr. Allen's cases require a reference, you can decide the EU points in this case in our favour without a reference, but you cannot decide them against us without a reference.
That's what most people say.
It may be. I've got to make it good in my case, and I will try and do that.
With greater or lesser plausibility, you would say greater on this occasion.
Very much greater, my lord, yes. Sixthly is the ECHR points, and that, of course, raises a separate set of issues. Can I start with my first head, which is the forward-looking nature of this claim? Lady, my lords, Mr. Walker, as I've said, brings no discrimination complaint about anything done by the respondents during his period of service, and nor could he. During that period, he was not married, nor was he in a civil partnership. So even if sexual orientation discrimination had been unlawful during that period, he and his partner would not have been in an analogous position to a married couple. So he could not, when one just goes back to the submissions made by Mr. Kavanagh just now about the date at which the cause of action accrues, if one asks that question, he could not have brought his discrimination claim at that time. It was when the legislation changed and Mr. Walker's partner became his civil partner that he acquired a legal status analogous to that of a spouse. And it was the refusal at that point to accord the benefit to Mr. Walker's civil partner that gave rise to the present litigation. That's how this litigation came into being. He asked at that point, Innospec, to confirm that they would pay the spouse's pension to his civil partner, and they said no. And that, of course, was all after the deadline for transposing the framework directive. So the discrimination complaint relates to an act done after the deadline for transposing the framework directive. More generally, the discrimination complained of here is discrimination that has not yet occurred. It will occur in the future, subject to the decision of this court, if Mr. Walker dies before his husband. And that's why the principal remedies sought in this case are declaratory rather than compensatory. Can I move then to Maruco and show you the facts of Maruco? But I've already tried to introduce it by saying this was a claim about survivor's pension and about sexual orientation discrimination, in which the service to which the pension related either entirely or almost entirely predated the coming into force of the framework directive. Can I ask you just to look at the decision of the opinion of the Advocate General to start with, so that we can get the facts of the case. And the facts of the case, of course, is what Advocate General Cocotte was referring to when she said that this case, like Roma, was a case where the service to which the pension related predated the transposition deadline for the framework directive. So if one takes up Authorities Bundle 1, tab 7, and goes to page 2, MS 260 in the decision of the advocate, the opinion of the Advocate General. So one can see from paragraph 16 that it was in 2001 that German law created for people of the same sex a family institution that resembled marriage, known as a life partnership. Mr. Maruco entered into a life partnership in 2001. That's paragraph 19. Mr. Maruco's partner had worked and paid pension contributions continuously from 1959, one sees that at paragraph 20, and he died in January 2005. Now, it's not clear from the Advocate General's opinion or from the court's judgment whether he was still working at the time of his death. We do know from the German court's judgment, when the matter returned to them, that he was born in 1933, so it seems quite likely that he would have been retired. He would have been 70 in 2003, so it seems quite likely that he would have been retired at that point. But even
Well,
just
I don't
assuming...
know. Theatrical costume designers could go on
Well,
forever, couldn't they?
I understand it's not clear, and I accept it's not clear from the facts. And so let's just assume, for present purposes, that he worked until his death. Even assuming that, only just over one of his 45 years of service post-dated the transposition deadline for the framework directive. So we would say that it is totally clear from the facts that if the Secretary of State's argument in the present cases were correct, Mr. Maruco should have received either nothing or almost nothing. As we shall see in a moment, that is not what the Advocate General or the Court of Justice or the German court held. Now, we can see from paragraph 21 that he applied for a widower's pension and he was refused on the basis that it was not available to life partners. So he brought a claim before the German court. The German court held that on a proper construction of the German pension provisions, the widower's pension was not available to life partners, and such differential treatment was permitted by national law. See paragraph 22. That being so, the only possible remedy open to Mr. Maruco was under EU law, hence the need to refer questions to the CJEU. See paragraph 23. Now, there is a suggestion in the Secretary of State's case that Maruco is different from our facts because German law had no equivalent of paragraph 18. That point is, we respectfully submit, completely without merit. The only threshold question in Maruco or this case is whether national law provides a remedy. If it does, then there's no need to invoke EU law at all. If not, there is a need to invoke EU law, and there is also a need to consider whether, on the facts, EU law supplies a remedy. As we shall see in both Maruco's and our case, national law did not provide a remedy, but EU law does. Now, questions 1 and 2, which are set out at paragraph 23, concern the scope of the directive and whether particular benefits and the particular scheme at issue came within the concept of pay in the directive. Question 4 concerned the effect of recital 22, which notes that the directive is without prejudice to marital status and the benefits dependent thereon. So questions 1, 2 and 4 were taken together, and the answer given by both the Advocate General and the court was that the scheme came within the concept of pay and recital 22 didn't make any difference.
Because the Germans had adopted life partnership.
Yes. Well, it's a separate question whether they come within the concept of pay. Oh, question 3 is the discrimination question, which I'm going to come to in just a moment. That's the important one for our purposes. So question 3 is the question that asks whether the directive precludes the differential treatment at issue. And the key part of the Advocate General's answer to it is at 96 and following in his opinion. So if one goes to that, that's MS 275. So he finds at paragraph 96 that there is no discrimination because the term widower is no direct discrimination because the term widower is restricted to a man in an opposite sex relationship. Now, we will come to see in a moment that the court did not agree with that analysis. The court said, no, the discrimination is direct, and we say the court was absolutely right on that. If you say the term widower is restricted to a man in an opposite sex relationship, you are admitting, not denying, direct discrimination. You are directly discriminating because of someone's sexual orientation. But at 97, you can see that he finds it necessary to go on to consider whether the national provisions give rise to indirect discrimination. And then at 99 to 100, he says that the answer to that depends on the point that my Lord Hughes just putting to me, the effects of the two types of union, marriage and life partnership, and on whether the legal situation of spouses is akin to that of persons in a registered civil partnership. And at 101, he notes that the German court thinks that the answer to that question is yes. And at 102, he says on that premise, the refusal of a pension is indirect discrimination, which at 104, he says, is not justified. He then moves on to deal with question 5 under the heading temporal limitation of the widower's pension. And as to that, at 108, he says that the case law permits a restriction of the right to rely on a provision only in exceptional circumstances where there's a risk of serious economic repercussions owing in particular to the large number of legal relationships entered into in good faith on the basis of rules considered to be validly in force. 109, he explains what type of analysis would be necessary if a Barber-type limitation were to be imposed. And 110, he says the court has two options, either rule on the question or not reply to it, which would enable it to be determined in another case with more evidence. He favours the second. Now, if one just looks at how the Court of Justice answered question 3, this is at paragraph 62 on page MS 287, they record at 64 the employer's submission that under German law, life partnership is a sui generis institution, not comparable to marriage. At 67, they make the point that life partnership has become gradually similar to marriage. And then at 68, they give an example, which is an example drawn from the Social Security Code, not dealing with the pension that we're concerned with here, but saying that is an example of the two statuses achieving comparability over time. The court then returns to the survivor's pension at issue in the proceedings. It makes the point that the referring court has already said, see paragraph 70, that German law, while conferring a right on spouses, does not confer any similar right on same-sex partners. So German law does not provide a remedy here, and goes on to say that this would be direct discrimination contrary to the directive if the referring court decides that surviving spouses and surviving life partners are in a comparable situation so far as concerns that survivor's benefit. Then at 74, the court deals with question 5. Mr. Allen has already drawn attention to the way that the court framed question 5. It asked whether the directive precludes legislation such as that at issue in the main proceedings. In the event that the court concludes that the directive precludes that legislation, entitlement to the survivor's benefit at issue in the main proceedings must be restricted in time, and in particular to periods subject to 17th May 1990 on the basis of the Barber case law. Then just look at the pension funds argument set out at paragraph 75. The pension fund considers, the authority considers, that the case which led to the judgment in Barber's case differs on its facts and in law from the case in the main proceedings, and Directive 2000 of 78 cannot be given retroactive effect by means of a decision that the directive applied at a date prior to the date of expiry of the period allowed to member states for its transposition. So we say that is exactly the argument being made here, and it must be that argument because this is somebody whose service entirely or almost entirely predated the transposition date. So it's the very argument that's being put here. And then the answer at 77, temporal limitations are exceptional, nothing in the material before the court to indicate that the financial balance of the scheme is likely to be retroactively disturbed if the effects of the judgment are not restricted in time. And then 79, the answer given is both general and unequivocal. It follows from the foregoing that the answer to the fifth question must be that there is no need to restrict the effects of this judgment in time. Now, can I just make this one point because I can see the time? On the respondent's case, there was no need to even consider limiting the effects of the judgment in time because EU law already imposed a much more severe restriction than was actually being asked about, namely a restriction from in respect of contributions made before 1990. On the respondent's case, one doesn't need to worry about contributions made before 1990 because all contributions made before 2003 have to be left out of account. And on the facts of this case, that means all of them, or almost all of them. And we say if that is what the court had thought, it is, with respect, extremely surprising that they do not mention it at all. My lady, I see the time, and that may be an appropriate moment at which to break.
Exactly so, Mr. Chamberlain. The court will now adjourn and look forward to hearing from you further at 10:30 tomorrow.